So I am an elder law special needs planning attorney. My office is down in Kirkwood. I am also a VA accredited attorney, so I do VA work. Uh, Mostly, my clients are going to be older, and so the programs I'm working the most often with are going to be the ones we kind of talk about on the tail end of this presentation. But I can do all of the things that we're. Nikki Mitchell. Yep.
Okay.
And it's on the handout you have. So we don't have a projection, so you do have the handouts in front of you for the slides on what we're going to be talking about. There are a couple of places in the slides where there are links, so I can send the electronic version if we're going to email that afterwards, so you can just click on those and get to where you're going. I am fine if you want to ask questions as we go along, so feel free to, as you think of them, interrupt me and we can talk about them. If it's something that I think will be covered later, I'll just let you know that, but go ahead and bring it up. So there's a roadmap at the beginning here just to kind of set out the few things that we're going to talk about. So I do want to be clear, we're not going to do, we only have an hour, right? So we're not going to do a super, super deep dive into any of these topics, but I did want to touch on some of the most popular benefits that you can get through the VA program, and some of them are run by sub-agencies we'll talk about, but they are all kind of under the rules of the VA. So we'll first talk about service-connected disability. That's a really big one and probably the program that takes up the most resources for the VA. That's what they're most often dealing with. We'll touch on healthcare services the VA provides and the burial funeral sub that is sort of attached to that. And then some special pension programs that they have at the end of this. Okay, so for all of these programs that we're going to talk about, there are three real basic requirements that everybody has to meet. So there's going to be additional requirements for each one, but you have to really meet these three basic ones no matter what. So first is that you have to be a veteran in the way that the VA defines that term. And that can be different for each of the programs, but whatever the definition is for the program, you have to be a veteran. You cannot have a dishonorable discharge. You can have honorable other than honorable, but you cannot have dishonorable discharge. If you have a dishonorable discharge, the VA doesn't consider you a veteran, so you don't meet that first prong. Then you have to establish your entitlement for whatever that benefit is. So we'll talk about them later, but if you're saying you have a service-connected disability, you have to prove how you qualify for that particular program. So those are the three big things, and we'll touch on more specifically how they overlap in these programs as we go through. So a couple of things to kind of keep in mind just in terminology, and I'll backtrack a little bit. So I was never active duty, but my dad was for my whole life. And then I married someone who was also in the Army, so I was a military spouse for 12 more years. So I've been military adjacent my entire life. So, I understand the life and the world and the acronyms and all that stuff. So feel free to kind of throw that stuff at me. That's fine. But I think that most of you here probably either were in the military or have a loved one who was. How many were active duty? Okay, and then have a loved one or someone else who was? Okay. So you probably know this as well, but I think it's really important just to say up front. So one of the things we're talking about, especially when we, is the difference between those compensation benefits and pension benefits. So compensation is simply that. It is monthly benefits that are paid out to you that are just based on the fact that you've earned it somehow, right? It doesn't have any, there's no sort of other financial requirements that you have to meet. It's not needs-based at all. So for example, service-connected disability benefits is a compensation program. By the very nature of having been disabled while you were in military service, you have now earned this compensation benefit. It is not needs-based, so it does not matter how much you have or what other income you have. Doesn't play a factor into that at all. That is also true for survivors benefits, which we're not going to talk about too much here, but there are certain benefits that surviving spouses and minor children can receive if someone who had a service-connected disability dies or someone who's on active duty dies. Then lastly, we'll have the improved pension programs, and those are needs-based. So those are things that you are entitled to by virtue of your service, but because it's paying out for disabilities that were not incurred during your service, they do have financial kind of strings attached. You have to meet the rules that they set for how much you can have or how much you can earn.
Excuse me.
Yep.
Does that mean that benefits are different for wartime veterans than, like, say, veterans that were sent out of the country, opposed to veterans that were here in the country?
It's not so much about where you served as it is about which program you're getting the benefits under. So if you are applying for those pension programs and you're a wartime veteran, then there's only one wartime period where it matters whether you were deployed into the wartime country or not, and that's Vietnam. And that has two separate things, and we'll talk about that in a bit. But otherwise, no. You would still technically be a wartime veteran or be entitled to these benefits even if you never left the United States, so long as it was during that
I
time.
only say that because my husband was a Vietnam veteran.
Mm-hmm.
His buddy served, but he didn't serve overseas.
Which means for them, then they have two different timelines they're looking at, and that's it.
And the benefits are different too.
Not for the pension programs. Now, if you're trying to say it's a disability benefit, it could be, but for the pension program, the benefit is the same if you were within that time frame. And we'll talk about that later. So we are, if you're following along, we're on the slide for the first slide for the service-connected disabilities. So service-connected disabilities, as I mentioned earlier, is a monthly payment payable to the veteran, not asset or income-based at all. What you have to show is that your injury or disability either was incurred during your active duty service, or if you had an existing condition that you came into the military with, that condition was aggravated during your active duty service. These ratings, that's what they call them, are percentage based. So from 0 to 100%, always in increments of 10. So you will never see someone who has 15 or 25% disability rating. It's always going to be 10, 20, 30. You can have a 0% rating that is what they call compensable, which means you still qualify to receive some monthly payment, or non-compensable, which means we're recognizing you have this condition, but it's not severe enough that we're going to pay you any money every month. So you can, when you submit an application for a service-connected disability, you put every condition you think that you qualify for on that claim form. Each one is evaluated separately, and each one is given its own percentage ranking. So you may have one that has a 10%, one that has a 40%, et cetera. The totality of those is added up to give you your final rating. So you can have 4 different conditions that you have some rating for, and the total of those 4 is 80%. So no one condition is fully disabling, but the totality of them can be. We'll talk about in a little bit why that rating can really be beneficial to you, in addition to the fact that the higher the rating, the more money you get every month. But also there's some other benefits you'll see as we go through here that open up to you. Plus, if you have a rating that is higher than 30%, then your dependents are also eligible for some benefits. So your monthly payment will be even higher because your spouse and dependent children will be included in the household size for how much money you're going to get. None of this income is subject to state or federal taxes. So you're not going to ever put that on a tax return. It may be includable if you are applying for some other needs-based programs, because it is still income to you. So those programs may ask about it, but not for tax purposes. So an example of that is I have clients who are in nursing homes applying for Medicaid, and they have service-connected disability compensation payments every month. Even though we don't claim that for taxes, I have to claim it as income for them on the Medicaid program. Yeah. So So something to keep in mind. Service-connected disability has 3 things we have to prove when you're submitting a claim. You have to show medical evidence of your disability. If you are claiming to have hypertension, for example, you have to show medical records that prove you have hypertension, right? Then you have to show that there's some record that started or was aggravated during your active duty service. So it is not necessary that your medical records while you were on active duty necessarily have that information, but you're going to have to at some point prove that there is a connection between the two. So your diagnosis can come later, but we've got to show that that happened during your service. And then we've got to show that there is what they call a nexus between that occurrence, that thing happening or being aggravated, and your disability. So a really common example, as we have kind of, come out of all of the Afghanistan, Iraq wars in the last 20 years, is PTSD claims. Those are very common claims being made. It is not uncommon that someone is diagnosed with PTSD once they're out of the military, for lots of reasons we could probably go on and on about. But if you're making a PTSD claim, so let's say you're seeing a psychiatrist, that person has diagnosed you with PTSD, so you have medical records that show that you do have PTSD. You are trying to show that started while you were on active duty service. One of the ways you can do that is to show that you were exposed to what they call stressors during your service, right? So even if the diagnosis was made later, if your medical records show, these were the certain stressors that contributed to your PTSD, and then you can go to your military records and show, I was deployed to combat 4 times, I did A, B, and C. You can make that connection between the two. That combat experience was related to you experiencing those stressors. Those stressors are what caused your PTSD. That is the chain that you're trying to connect for the people who are evaluating your claims. For some people, this is all happening before you even get discharged from the military, right? So you are, as part of your outgoing process, already have this diagnosis. You already know that you want to make a claim for this, so you're filing that all then. But it is possible to file many, many years later. You do not have to do it before you get out or even right after you get out. And that is a really good example of that is the next slide, which is the presumptive conditions list that the VA has put out. So the presumptive conditions are basically saying we are recognizing that if you have this condition and you served during a specific time frame, there is a nexus between those two things. You don't have to prove that nexus. We're just saying that already exists. And so that is especially clear in the Agent Orange exposure condition. So for people who were in Vietnam and also some time frames after that, if you can show on your military record, I was in Vietnam, and you have one of the conditions on there is neuropathy. I have neuropathy. I was in Vietnam. I don't have to prove the nexus. It's already, all I have to show is I have neuropathy and I was in Vietnam. So it's a much easier way to make a claim that's processed much more quickly. And they are constantly adding conditions to that list of presumptive conditions. So it's something like if you applied, 10 years ago for a condition that was not at the time on the list, but is now, you can go back and reapply. And one second. And you can, in some cases, there was a new, basically the VA's version of a class action settlement that says you can get back paid all the way to that original application. So you can ask that, you have 10 years of back pay. They've paid out millions of dollars on those claims at this point. So it is something that could potentially be really financially significant. Yes.
Question
Mhm.
about the presumptive conditions. If someone died before the contact took place and their conditions on the list,
Mhm.
do they
So you can do a substitution of claim. So a family member can bring a claim on their behalf in some cases. If they had a claim pending, you can easily continue the claim. That's pretty clear, but there are some restrictions on when you can file it if you did not have a claim pending when the person died. That would be something we would want to talk about like on an individual basis, but it is possible. And then the payment would be from whenever the condition started to when the person died. So you're not going to get continuing benefits necessarily, depending on whether you qualify for some of those survivors benefits I mentioned earlier. But you would get at least that lump sum payment for that time frame you can prove while the person was living. Yeah. And then you mentioned the PACT Act. So you can see the PACT Act was passed in August of 2022. That added some presumptive conditions for burn pits, asbestos, and some other toxic substances people were exposed to in more recent combat zones. So not, because before it really was kind of focused on the Korean War, Vietnam War. So now they bring it up so people who were in Iraq in the early 90s and Iraq and Afghanistan in the 2000s can qualify. So that's one of the links that's in there. You can click on the link. It's updated all the time for the conditions that are on there. I will just make a note that some of those presumptive conditions do have time limits on them. You have to have been diagnosed within a year of service. So not all of them, but some of them. So when I said earlier you can apply much later, that is true, with some exceptions. Okay. Okay, so that's service-connected disability. Like I said, we're not doing a super deep dive, so that's a very surface overview. There's a lot of nuance to that. Does anybody have any questions about that piece of it before we move on? Okay.
Do you work on these cases per se?
Yes, sometimes the service-connected stuff I do. It's mostly in the for the Korean, Vietnam era people because I'm working with them on other things at the same time. But I mean, I can do those. There are people who do only VA work, only for service-connected disability stuff, and so if you haven't filed a claim and you want to, I can give you some names for them too.
You can do what?
Give you names for them as well.
Okay.
Yeah. Okay, so moving on to the healthcare with the VA. So the VA does provide healthcare for veterans. They prioritize those services through 8 groups that they've ranked everybody into. So on your slide, you can see what they are. So the priority group 1, these are the people who have first dibs on available appointments and services. Our SCD is service-connected disability on this sheet. So have a service-connected disability rating greater than 50%, or they're unemployable because of their service-connected disability, or they're a Medal of Honor recipient. Those people are going to get priority ranking. Priority group 2 is a service-connected disability rating of 30 or 40%.
What page are you on?
Yeah. I don't know what your pages look like. Mine are numbered differently.
Okay.
There you go. Priority group 3 is prisoner of war, Purple Heart. If you had a medical discharge from active duty, if you have a service-connected disability of 10 or 20%, or were awarded special eligibility classification, which is a very narrow thing that not very many people fit into, but would allow you to kind of move up the ranks through the priority groups. Priority group 4 is if you're receiving aid and attendance or housebound benefits or are catastrophically disabled. Those are those pension benefits that we'll talk about in a minute. If you have priority group number 5, you have no service-connected disability or one of those non-compensable 0% ratings, and you are low income, getting pension benefits, or are eligible for Medicaid. The other ones below that, I'll just let you read them, but just a note on this, which is that as you get lower down in this group, it gets harder and harder, practically speaking, to actually get healthcare services from the VA in any sort of timely fashion. There are just too many people who technically fall into these groups and not enough VA providers to provide all of that care. So you can see how getting your service-connected disability rating as high as possible opens up a lot of these programs because you're going to get higher up in those priority groups.
Does the assigned group have anything to do with you get pharmacy benefits?
So if you're eligible for the care, then then pharmacy is included in that. So, but it's just going to be a matter of getting in. You have to be assigned a provider a lot of times before you can access those other sort of ancillary benefits. So on the next page, you'll see there are currently 170 VA facilities. So it seems like that would be enough, right? Like that should be a lot. We should be able to provide all 8 of those priority groups with care, but it's just not enough people. We also have 300 counseling centers and over 1,000 outpatient clinics. But the buildings are there, the providers are not necessarily. If you are eligible for healthcare with the VA under one of those groups, then you're eligible for general, regular healthcare benefits. So kind of thing we would all think about if we have health insurance, which is doctor's visits, hospital stays, prescriptions, procedures, and patient care. There is also a program that started a few years ago that makes payments to caregivers of veterans. So this has been true for many, many years if you were receiving some of those pension program benefits like the aid and attendance, but now they've opened that up to people who have service-connected disabilities and have a caregiver who may be a family member who has maybe had to reduce work or quit work in order to provide that care. So they will give them a monthly payment, and that person is also eligible for some healthcare benefits and some respite services, which would allow them to get a break every once in a while. The VA also does cover substance abuse and behavioral health services. There are some inpatient rehab facilities run by the VA for people who need it, and inpatient behavioral health facilities. You can also receive counseling and treatment for military sexual trauma. You don't have to have made a claim that you experienced military sexual trauma while you were active duty in order to receive those benefits. That's something that can come later. You never have to make a formal claim in order to get those benefits. The other thing that they do have, and I put a star next to this because it can be limited, but they do have some in-home long-term healthcare benefits where they will have in-home care providers come and provide services at your home. But that is limited, and it seems to be sort of the political football. It's part of the program that gets played with during different administrations on whether they're going to provide it or not. So that's something where the benefits are always kind of expanding and constricting depending on the administration. They do have community living centers. They're sort of like day programs, like adult daycare type programs. And they have contracts with private nursing homes to provide nursing home care. So if you were someone who was in like that priority 1 group, you potentially, if you needed to go to a skilled nursing facility, could have the VA cover that completely through one of those contracts. In addition, there are some state-run nursing homes. So in Missouri, we have 7 of them. They're run by the Missouri, the Veterans Service Commission, the VSC. Those are run by the state, so not by the VA directly, and funded by a lot of state dollars, but the cost of them is low. So for example, the ones in Missouri only cost roughly $2,100 a month right now for someone to go, as compared to if you went to a private skilled nursing facility right now in our area, it would cost you around $10,000 a month. So it's a significant discount on long-term care services.
I understand that what the veteran pays is based on their income.
For the
For the
long,
state run.
no, so that amount is fixed. If you had much lower income or much lower assets, then you could potentially pay less, but you have to apply for that and get approved for it. Otherwise, they don't even ask about your assets. There's a spot on the application where you can say, I don't want to disclose my assets. And then you just pay that $2,100 and that's it.
So getting the 2,200 and whatever amount is really important. It's gonna take it all.
For the aid and attendance, yeah, it will basically cover the care completely at that facility. There is, because we only have 7, there is generally a wait list always for those places. So last time I heard it was somewhere between 6 and 10 months, depending on which one you were trying to get into. And the one up here in North County is the largest of the 7, has the most beds, and also has a really long wait list. So
I understand that a female veteran, though, has a different, shorter wait list.
used to be, yes, and that's because so many of the veterans eligible who are in the age range that require skilled nursing are men. There are far fewer female veterans at that point, so there just aren't as many women applying. So it's just a supply and demand thing.
But is there a shorter wait list? My mom was a veteran.
There would be, but there are also fewer female beds.
Ah,
So you're probably still gonna wait. It may be slightly different, but you're still gonna wait because they're not allocating them. And some of them, if I remember correctly, don't. It's just for men, for the state-run ones. There might be some that allow women, but not as many. Okay, so any more questions on the healthcare stuff before I move? Yep.
Are the long-term care benefits, is that income dependent?
No, it is if you fall into one of those priority groups. So whatever your priority group is going to dictate kind of your access to those programs. But if you get access, it's not dependent on your income. If you're in one of those lower priority groups, like that 6, 7, 8 range, you're probably not going to get it. And those do sometimes have sliding scale stuff. So you will have some income things on there. But that's true of all the programs you might get from the VA for that, not just long-term care. Because on those, they're kind of asking you to pay premiums and deductibles and stuff. It functions more like private health insurance when you get into those lower priority groups. Okay, so now let's turn to the burial and funeral services. So these programs are actually is one of the ones that's run by a sub-agency of the VA. So it's the National Cemetery Association is who administers all of these programs. They are open to eligible veterans and their family members. In some cases, you'll see as we go through here. But this program allows for burial allowances, which are not huge. They're not super significant, but it is money available. So if you died during your active duty service, your burial allowance is $2,000 plus they will cover some or all of the cost of transportation of the body to wherever the burial is going to take place. There is no deadline to request this. So if someone died during service and you did not make that request initially, you can do it at any time after, and you'll just get the check to reimburse you for whatever you paid out on your own. If it was not a service-related death, then you will get $893. You do not get those transportation costs generally, and there is a 2-year deadline to make that request. So it's a little bit different depending on whether you were active duty or not. So in addition to the burial allowance, and I'll just note, like for service-related deaths, that is separate from all of the like life insurance benefits and other payouts that would be coming. This is on top of that, so this is a separate thing. So you're also entitled to grave markers. So the veteran can have a free grave marker at any cemetery. It can be private or one of the state-run veteran cemeteries or one of the national cemeteries, it doesn't matter. Spouses and dependents are also eligible for a grave marker if it's in an approved cemetery. So generally, private cemeteries don't count, but if you were in a state veteran cemetery, you could have spouses and dependents get grave markers as well. This is also the agency that provides burial flags for funerals. And they coordinate, even though technically the DoD runs the program for military honors funerals. So the DoD is the one who's providing the actual soldiers who come with the rifles and things like that, but this association is the one that coordinates those benefits. So that's who you would make a request to if you did want military honors at your funeral, and they will coordinate that and have them come out. It is also the group that arranges for burial at Arlington National Cemetery or burial at sea for sailors. So those are, the burial at sea is not limited, but Arlington National Cemetery is harder and harder to get into. They're running out of space. And so not only can it be hard to get approved to get in there, just space-wise, but it does sometimes take a long time before they can actually have the service, because for a while there were too many backed up and they didn't have enough people to actually like perform the ceremonies. But if you wanted that, you would make the request to the National Cemetery Association. Couple of notes. So like for us, if you wanted to be buried at Jefferson Barracks, you can actually submit the forms in advance. This was passed a few years ago. You used to have to wait until somebody passed away before you could start doing all of this. Now you can do it in advance. So there are forms available online. If you want to go in and make the request that you're going to be buried at JB, if you have a spouse who is going to be buried with you, you can provide their information and go ahead and have grave marker information, that kind of stuff lined up. So there's less to do when somebody actually passes away. Service at those, by the way, or burial at those has no cost. So there is no fee unless you're going to do some sort of like graveside service, and then you may have to pay for whatever you're going to set up for that. Okay, so that's burial stuff. Any questions? Because now we're going to head into the pension and aid and attendance benefits and those things, and that one has a lot more rules about it. So tend to have more questions. So we'll want to make sure we have time for that. So, okay. All right. So improved pension programs, which is the formal name, but most of the time you're going to hear it called aid and attendance, housebound benefits. Most of the time you're going to hear aid and attendance because housebound is kind of lumped in there. This program has a service requirement, a medical requirement, and a financial requirement. So this is one of the ones where it does matter how much you have. All right, so the service requirement for aid and attendance is you have to have been on active duty for 90 days. And at least one of those days has to have been during a wartime period. And we'll on the next slide, we'll show you what those periods are. As in the other programs, you have to have some discharge status that was not dishonorable. And then I'll just make a note about reserves and National Guard, because I've several times had people come in and meet with me thinking that they are eligible because they were called up to active duty from the National Guard or the reserves. You have to have been called up to active duty on federal orders in order to qualify for this, in order for that active duty time to count. If you were National Guard and the governor called you up to active duty, then it does not count. And that is not known by everybody and really disappointing for people who think that they would otherwise be eligible for this. So 90 days active duty, 1 day in a wartime period. The wartime periods, as they are currently set, are on the next page. So they don't always align with what we would consider as being the start or the end of any given war. So it's important to, if you're pulling this up, pull out your either separation papers if it was World War II or your DD 214 for everything else, and compare your dates of service and make sure at least 1 day falls within these periods. So for World War II, it's from July 12th, 1941 to December 31st, 1946. There are fewer and fewer World War II veterans coming, but as we'll talk about in a minute, surviving spouses are eligible for this benefit as well based on their spouse's service record. So we do have some spouses whose husbands served in World War II who are coming and applying for the benefit. And then, as I mentioned earlier, that Vietnam War period, there's 2 different sets of dates. So if you actually served in Vietnam during that war, you're bound by that first date, the February 28th, 1961 till May 7th, 1975. That does include if you were in the Navy and you were on a ship in what they would call the blue water zone, which is right outside of the country, but you were not actually on the land. But if you served anywhere else during the Vietnam War and not in country, then your dates are August 5th, 1964 to May 7th, 1975. So you don't get the benefit of the first, like roughly 3 years of that wartime period if you did not serve in Vietnam. Korean War, 27th June 1950 to January 31st, 55. And then the Persian Gulf War, the period starts on February 8th, 1990. You'll see it's TBD. They have not set an end date to the Persian Gulf War, which has very clearly ended a long time ago, but they have not set what that end date is going to be for that program. And they haven't put any dates out for anything after that. Afghanistan, Iraq, none of that stuff has come out yet. So, a lot of that has to do with, at least for the more recent stuff, that those people aren't in an age group where we think they're going to be on this program, or they maybe have a service-connected disability, so they don't need this particular program as much, but still, it's not out there yet. And as I mentioned earlier, if you meet that service requirement, and you meet these medical requirements that we're going to talk about in a second, your benefit is the same. They don't really differentiate on how much you're going to get every month. One thing that can be different, I guess I'll mention, is if you were receiving service-connected disability benefits and then came and applied for this, then there would be some overlap between that. That can cause a little bit of a change, which is the same as if you retired from, 20 years or more of active duty service and were receiving retirement benefits from the military and then applied for service-connected disability. Those benefits are going to change too, because now you're getting, you're pulling from 2 different pots of money basically. So it's the same for this one. Yeah.
It doesn't affect you, I think, if you're over 60%. My husband was out. They didn't decrease.
If you're getting retirement benefits and service-connected, yes, there's some rules about when it does and when it doesn't affect you, but generally speaking, you're at least going to have to go through the VA is at least going to work that up when they're reviewing all the claims to see whether or not they're going to reduce one or the other because you're receiving both. Yeah. Okay, so for the pension programs, the medical requirement is that you have to be considered permanently and totally disabled. So there's a list here of what that could mean to be permanently and totally disabled. It doesn't necessarily mean that you're completely incapable of doing anything for yourself, or are just in bed all day. Even when they say housebound, they don't mean that you literally can't leave. They just mean you need someone's help in order to really be able to do it. So this requirement is easily met if you're in an assisted living or skilled nursing facility, because that very clearly shows that you need help with your activities of daily living, that some other person has to assist you to get those done. And then when you fill out a claim for this pension, you do have to get certification from whoever is providing those services, whether it's in-home care assisted living, skilled nursing, there's a form they're gonna have to complete to sign off to show, like, they're gonna say, this is the assistance you receive and they are providing it for you. If you're receiving in-home care, an important thing to note is it doesn't have to be by an agency. You could be receiving in-home care by a family member, and that still qualifies. And you can then pay that person using the money that you get from this pension program. And in fact, I would actually recommend that you pay them before that if you can swing it, just because you'll see in a minute why that would make a difference to the financial piece that we're talking about. And so it's going to show that you have these out-of-pocket expenses that need to be reimbursed. So generally speaking, those first two prongs of this are pretty easy to show. We can pretty quickly show whether or not you meet the service requirement and whether or not you meet the medical requirement. Where we get into the weeds a little bit with people is on this financial requirement. And this is new as of 2018. Pre-2018, it's kind of like the Wild Wild West. There was no like set in stone rule, bright line limit about what made somebody financially eligible or not. So for better or worse, we now have these very clear rules about when you're eligible or not, but it is more restrictive than it was pre-2018. So now what they did, these rules, when they came into place, were meant to mimic Medicaid's rules for nursing home care. So there are a lot of similarities. There are some important differences, though, that I'll point out as we go along. But just to kind of be a little bit different and keep us on our toes, what the VA now calls it is your net worth limit. And it has to be below whatever the limit is, which changes December 1st of every year. The net worth is equal to your income for VA purposes, which they call IVAP, plus your covered assets. If you are married, you have to include the income and resources of both spouses, and it doesn't matter whose name is on the title, who owns the account. They assume if you're married, both spouses have equal access to all of the money, and so therefore you're gonna have to put all of it on the application. Another thing to note is, I mentioned earlier that surviving spouses are eligible for this benefit using the deceased spouse's service record. While both spouses are living, let's say you have a husband and wife, husband served and he meets all the requirements, but it's the wife who's the disabled one who needs the benefit. You can't get this benefit based on her needs because the veteran is still living. So while the veteran is living, it's only the veteran's disability that factors into this.
Do you know what the limit net worth is currently for single?
Yep. Well, it's the same for single or married. It's the same for single and married. It doesn't matter. But it's a little over $150,000. And we'll talk about that a little bit. All right. So if you are eligible for this program, there's a chart on here that shows you as of 2023 what the amounts are going to be. So if you're a single veteran, then you're going to get $22.89 a month. If you're a married veteran, you get $26.42. If you're a widowed spouse, so that's the survivor's benefit, $14.32, so it's less, but you're still eligible. And if you're a married veteran and both of you are veterans who are both eligible for aid and attendance benefits, then you get a little over $3,500. So that amount is just fixed. If you get approved for it, the VA is going to deposit it in your account every month, and then you use it as you need to use it. They're not going to say, they're not going to pay it directly to a facility. They're not going to pay it and say, I want you to kind of report back to me where this goes. You're just going to spend it. The only caveat to that is if it's getting paid out to a fiduciary on someone's behalf, so if someone's incapacitated and can't manage their own money, so the VA pays it out to this other person, that person does have to kind of report back what they do with it. But short of that, they don't care.
The physician certification, is that done by a VA doctor or
Whoever the doctor is. So like I said, in 2018, this changed pretty significantly. A couple of the big things that went into effect are on the slide here. So they established that net worth limit. It used to be if you have a house, they're not gonna count it at all. You're allowed to have a house, they didn't care what it was worth, how big it was, nothing. In 2018, they decided that weren't going to count the value of it. There was no limit to how much it could be worth, but they were, for some reason, going to limit the lot size to 2 acres. It doesn't really make, to me, any sense. I don't know what the logic was behind that, but now, so if you live on a property with more than 2 acres, we're going to have to jump through some extra hoops to show why those should not count against you, or the value of them should not count toward that net worth. They also changed how they look at trusts and annuities. It was very, very common pre-2018 to take everything and park it in an irrevocable trust and then apply for this benefit. You cannot do that anymore. And they also will not allow some of these annuities that you do use for Medicaid planning all the time. So that's another one of those changes between the two programs that makes it a little hard to do planning sometimes. And pre-2018, you could take all that stuff and put it in that trust and nobody cared. They didn't penalize you for that. Now, there's a look back period. So if you give away assets or sell them for less than fair market value within 3 years of applying, then there'll be a penalty. And we'll talk about that in a minute. They did also change, I think for the better, by creating a list of what they consider medical expenses and custodial care. They defined those more clearly in the regulation so that we now have like a more robust list of things we can take as an unreimbursed medical expense, which you'll see how that factors into it later. Okay. So as I said, the 2023 net worth limit is $150,538. That will change every December 1st. That number changes, as does those monthly benefit amounts, December 1st every year. Net worth, again, is IVAP and covered assets. Non-covered assets include your primary residence, again with the star, because if it's more than 2 acres, it's not fully excluded. One vehicle of any value, your personal property, which in Missouri has a bit of a different meaning to us. So it does not mean all the stuff you put on your personal property return and pay taxes on. It is the stuff that's inside your house, those kinds of things. If you have a burial plot, the value of that is excluded. And if you have an irrevocable prepaid funeral plan, they exclude that of any value. So long as that contract is irrevocable though. But that's it. So everything else is going to be factored into that net worth calculation. Getting close on time, so I'm going to go through a couple of these pretty quickly, and there's a scenario at the end if we don't have time for, you can kind of go through on your own, so we'll just play it by ear. Okay, so IVAP, which is that income for VA purposes, is your gross income from all sources minus your unreimbursed medical expenses. So if my gross income every year is $50,000, but I'm paying out $40,000 to care for assisted living every year, then my income, my IVAP is $10,000, right? I've listed some things below there in that that new regulation that defined those medical expenses a little bit better on what unreimbursed medical expenses can be, but certainly any payments to healthcare providers count. Health insurance premiums count, so you can deduct the cost of like your Medicare premium if you've got any supplements, all that comes off of it. Medications, medical supplies, and that includes over-the-counter type stuff. So if you track all of that, we can deduct it. The only thing is that your IVAP can't be less than 0. Some people thought when these rules were first proposed, oh great, well we've got tons of, right, because skilled nursing is $10,000, so I'm going to take $120,000 off of my regular income and I'm going to have negative IVAP. So that means I can have more assets. But the VA said, nope, the most you can get it down to is 0. So then you'd have $150,000 in assets and still be within the limit. But you cannot go into a negative range, even if you do have more out-of-pocket expenses than income. And again, on this side, the whole 2-acre thing. What we've got to show if you have a lot that is more than 2 acres is that it's not marketable. it's not, we can't sell it and make money off of it for one reason or another, either because you live in a place that says you have to be on at least a 3-acre lot, or you can't get access to the other parts of the land without, going through things, something, but we've got to provide documentation to the VA about why that is. Otherwise, if you had 10 extra acres on your property, they're going to count whatever the value of that acreage is against your net worth limit. Another couple of things on this slide. I don't want to dwell on it too long, but there are some things particular to the house. If you sold it this year, that money you get from the sale does not actually count against you until January 1st of the next year. So you have that much time to spend it or buy a new property if that's what you're going to do with it, or do something with it so it doesn't count against your net worth. It is also true that sometimes we can still put the house into one of those irrevocable trusts. That's like just a planning technique because it doesn't count against you. So we can transfer some of these non-covered assets without penalty. Okay, so speaking of the penalty, if you transfer, give away, sell for less than fair market value something within 3 months of applying, you're going to be penalized. The penalty is that you don't get your monthly benefit for a certain amount of time. The length of time is determined by the value of what you gave away, then divided by whatever their penalty divisor is for this year, which is always going to be the same as that aid and attendance monthly amount for a married person. So right now that's $26.42. So if you give away $50,000, they divide that by $26.42. That kicks out a period, however many months that is. You don't receive your monthly benefit for that long. That penalty cannot begin until you've made your claim. So for most people, I wouldn't say that. Depending on how things work, it makes sense to just wait out the 3 years. If you're going to give a bunch of stuff away, we figure out how to wait it out. The maximum penalty period is 5 years, though. So that's different than Medicaid, because Medicaid also has a look-back period, which is 5 years. But Medicaid does not have a limit on how long the penalty can be. So if you gave away enough money, you could have a 6, 7, 8-year penalty for Medicaid that the VA is not going to impose. They did cap it at 5 years. But of course, if you gave away enough money that your penalty is going to be 5 years and the look back is only 3 years, we just wait out the look back and then apply, so you don't have to worry about the penalty at all, right? So, and then as I mentioned earlier, only covered assets are subject to that penalty. So there are some planning opportunities we have where we can still try to protect assets. And this is really true if I'm talking to somebody who's on home care or assisted living, but they may need nursing home care in the next several years. So we're really thinking about trying to preserve Medicaid eligibility. So we want this VA benefit to help pay for stuff now, but we don't want to make them ineligible for Medicaid in the future if they go to a nursing home. This is something we can kind of do because there's an overlap here on those penalty rules that we can take advantage of by transferring some stuff now, still getting the VA money to help pay for care. And then if you needed in 5 years nursing home, everything you've put in that trust doesn't count for Medicaid purposes. So for example, if your net worth was $105,000, you're already within that $150,000 range. So if you took $100,000 and gave it away, you haven't done anything that changes your eligibility status. So they're not going to penalize you. And that's a weird kind of quirk in the rules. I'm not going to go too much into the trust and annuities and how they deal with that, except to say something that is really different in the VA world than with Medicaid is in Medicaid, you can transfer in trust everything to a disabled child without any penalties. You can only do that for the VA if the VA has determined that your child is incapable of self-support. So you have to have that certification before you make the transfer or they will penalize it. So that's an important thing to note because it's very common that one of the things we do for people who are on Medicaid, but have like an adult disabled child they've been taking care of their whole life, is to give that child the money in a special needs trust. And we can't do that here.